Good afternoon to all of you. This is Hamid Korsanchan on behalf of Pickering. I would like to thank you for joining us this afternoon and spending your great day with us. It is our privilege to have Paria from WP. Paria is focused on all residential and commercial real estate, and today she will be going over great topic of assignment. And we as a realtors are always dealing with assignment, and it is a great webinar to be part of it. And once again, I would like to thank Mrs. Rod for allowing us to be part of us as well. We all know it is end of the month. We talked a few minutes ago that it is end of the month and she's really busy, but with all of her work that she has today, she has put a 1 hour of her time for Pickering and all the members to provide information about new building assignment and changes to Tarion that Mrs. Rod will present today. Without any further ado, I would like to introduce you to Mrs. Paria Rod from Real Estate Lawyer.
Thank you. Thank you for the warm introduction, and thank you for having me today. My name is Paria Rod. I'm a partner and real estate lawyer at the law office of Woitzik Polsinelli. Our group is 5 lawyers, 20 support staff. We are primarily a real estate law firm here at Woitzik Polsinelli. We do have a sister firm, and our sister firm is Devery Smith Frank LLP. They are a mid-sized law firm with 70 lawyers, and their focus is on all areas of the law, whereas here at Woitzik Polsinelli, our primary focus is real estate. So today's topic is obviously going to be assignments. I'm very excited to talk to you. The point of today's presentation is not to confuse you, but just to make things more clear, I hope. Now, as you know, it's been a very, very interesting market. Last year, I attended a conference where one of the top analyzers for the market for one of the top banks appeared, and I'm not going to mention any names, but he essentially predicted that because of COVID-19, that the deal volume will substantially drop. As you know, the market is very strong. Deals are closing. So with that comes obviously the interest in assignments, right? You have clients who've entered into agreement of purchase and sale. There is a significant increase in the market, and they want to take advantage of that. And they may not want to qualify for financing or close a transaction and pay land transfer tax and pay builder adjustments. So really, it is a time where you do see an increase in assignment transactions. Now, as of June 1st, with the new stress testing rules, I mean, the hope, I guess they're trying to cool down the market, but with the very low interest rates, I think, and I guess nobody knows for sure, but it will be a very strong market. So let's start with today's presentation. So I'm just going to share my screen here with you. So there's a nice picture of me when I brush my hair. That's a joke. But okay, so we'll start with assignments. What are we doing when we're dealing with an assignment? You're essentially selling that piece of paper. You're not really selling the property. You're selling your right to acquire that property. So when you have clients entering into that agreement, the client is selling the right to acquire that property, okay? So what are the common issues that I see across my desk? And the common issues that we're going to be touching upon today is obviously builder consent. We're going to be talking about HST rebate and how that plays in when you have an assignment. We're going to talk about HST. Does the assignment, agreement of purchase and sale, does the transaction attract any HST? Eligibility for the HST new rebate, and talking about how should the funds be transferred. How do you establish a closing date? When are you going to exchange those funds in turn for the contract? And we'll talk about land transfer tax when dealing with assignments, and just talking about some of the costs, who pays what, okay? So we'll start with the basics, and the basics are when you are dealing with a client, who is wanting to assign their interest in a contract, it's really, really, really important to make sure that you do not advise your client to enter into a firm agreement of purchase and sale for the assignor. You have to make sure that that contract is conditional on granting consent from the builder. I have seen agreements cross my desk where there is no clause for consent, and that could really put your client in a position where they're in breach of contract, and they can be responsible for damages to the assignee. So you want to make sure that you do have that clause, of course, when that clause is inserted, following execution of the contract, the assignor's lawyer is going to write to the builder, and they're going to ask for consent. And the consent is really at the discretion of the builder, okay? So if, I haven't seen too many builders refuse. I have seen some, but I mean, for the most part, it really depends on the project. That consent needs to be obtained. And not only do you need to have a clause for getting consent, but you also want to make sure that you have a clause that gives the assignee, if you're acting for the assignee or the assignor, the opportunity for their lawyer to review that consent document. Because believe it or not, that consent document does include some things that could really affect the transaction, like the HST rebate, which we're going to talk about shortly, okay? So even if at the onset, when the assignment agreement was, when the purchaser essentially bought from the builder, even if they had an amendment that gave them the right to assign, in the fine print, there will be a clause that will say consent is still necessary. So no matter what, if you're doing an assignment of agreement of purchase and sale, you're going to want to have a conditional on consent, okay? So HST new housing rebate, what is it? So for today's presentation, when we're talking about HST, there are two components. Sometimes, it does confuse some people, so I want to make sure that we're dealing with two separate things. One is the HST new housing rebate, and the other is HST that we're going to be talking about. So the HST new housing rebate. Well, what is it? When the buyer goes to the sales office and they sign a contract, and for example, let's say I walk in and I sign a contract for a purchase price of $500,000, that $500,000 automatically includes the HST component, and it also includes, it's net of the HST rebate. So it means that the builder has already given the HST rebate right at the onset, but it really depends on whether you qualify for it or not. So if you don't qualify, you're going to have to pay that HST rebate in addition to the purchase price on closing. And the amount for the provincial HST rebate, the maximum amount is $24,000, okay? And for the federal portion, which right now, not a lot of people really qualify because your purchase price has to be under $450,000. So the federal portion is $6,300. So that really means that if you don't qualify for the HST rebate, it's an additional $24,000 cost to your client, okay? So what are the eligibility criteria? How do you qualify for the HST rebate? Well, firstly, you have to be an individual, okay? If the person that's buying the subject land or the property is a corporation on that offer, you're automatically disqualified, okay? So if you have somebody who says, hey, I want to enter into a contract, I want it to be in my corporate name, you should really let them know that only an individual can qualify for the HST rebate, okay? It has to be a new build, it has to be from a builder, and the property has to be the primary place of residence for them or for their blood relation, okay? So what does it mean for it to be their primary place of residence? The legislation doesn't specify a timeline, okay? Generally, they should be living in the property for about 6 to 12 months. They have to demonstrate that they intended for the property to be their home, okay? So you can't move in for 2 weeks and say it's my primary place of residence. And if you ever get audited by CRA, they're going to ask you for substantial evidence like Uber receipts, shipping labels, Amazon. Like you're going to have to demonstrate that it was your primary place of residence. Okay. So if they're not living in there themselves, but they have a blood relation, okay, who is a blood relation? Children, parents, grandparents, okay. So if I buy the property and I have my kids move in, and it's their primary place of residence, I still qualify for that $24,000 HST rebate, okay. Now, the way this looks, so to kind of simplify it for you, I've done an example here. So if you're walking into the sales office, you sign a contract for $1.6 million, that really means your purchase price is this amount here, and then you have the HST component, and then you get the rebate. So if you add up the HST with the net price, and then give yourself a credit for the $24,000, you will get 1.6 million. Okay, so when I say that the HST rebate is already included in this price, it means you're signing a contract for 1.6 million, but this 1.6 million has already factored in the HST and has already given you the 24,000. So if you qualify for the 24,000, great. If you don't, you're going to pay 1.6 million plus $24,000 here. Okay. Okay, so what's the problem? I mean, I explained what the HST rebate is. I explained that it's included as part of the original builder purchase price. But how does that really play in when you're dealing with the assignment? What's the problem? The problem is that most builders, so on closing, essentially that $24,000 is assigned to the builder, and the builder will claim that $24,000 from CRA, okay? So when you're dealing with the assignment, most builders will actually not grant the $24,000 HST rebate to the assignee on closing. And the reason for that is, as part of the original agreement of purchase and sale, the builder reserves the right. It's at their discretion, that granting of the HST rebate. So when it comes to assignment, the builder doesn't want to take the risk of possibly not being able to get that $24,000 from CRA. So automatically they will say, no, we will not give the assignee the HST rebate, and that the assignee will have to pay for it in addition to the purchase price. So that means that your assignee client has to pay the assignment fee, okay? We'll talk about HST as well, but they have to pay the assignment fee, they gotta pay the closing costs, land transfer tax, builder adjustments, which usually is about 2 to 4% of the purchase price. And now, on top of all of that, they have to come up with an additional $24,000, okay? Now, I have clients who say, that's fine, I have the extra cash, I will pay for it, and then I'm going to make an application with CRA after closing, and I'll ask to get that back if I qualify. And I have other clients who are first-time home buyers, and they say, look, I really just have the money for my down payment, and I'm borrowing some money from my parents for the closing costs, or I have just enough, and I won't be able to come up with that additional $24,000. So the implication is huge for some clients who may not have the necessary additional $24,000 budget. And when dealing with your clients, you really just have to, when they're entering into these types of agreements, you really have to just give them a realistic expectation of the cost, right? My clients, I've had clients who say, no, I can't come up with more. And if that's the case, and they won't be able to take the risk and come up with an additional $24,000, as their agent, you should really be protecting that. And to do so, I would recommend inserting a clause that makes the offer conditional on confirmation from the builder vendor as to whether they will grant the HST rebate or not. So as I said, about 90% of builders will say, no, you need to come up, we're not going to give you the HST rebate. I mean, I've seen some builders, if the assignee qualifies for it, I've seen them grant it. So if you have a deal that's really contingent on that $24,000, if it's going to break or seal the deal, then you can insert a clause that says the assignment agreement is conditional upon the assignee receiving written confirmation from the vendor that the HST new housing rebate will be credited on closing. And then once you have that clause in there, you refer your client to a real estate lawyer and you make them do all the work. So you can come to me or my colleagues out in Ontario, and they will write to the builder and they will ask the builder and express to them that we have a assignee client who is essentially going to be living in the property, and can you please confirm that you're going to honor the HST rebate on closing, okay? But it's really important to have this in there for clients who may not have the necessary budget, so that additional $24,000, okay? Now, going back to the HST new housing rebate, the assignee will only really qualify for the HST rebate if it's their primary place of residence, if they're going to be living in there, but also you have to make sure that that unit has never been occupied before. So what does that mean? That means if the property no one has occupied it, it's still vacant, that the assignee can apply for that CRA HST rebate, or if the builder agrees to honor it, great. Otherwise, if you're in a situation where occupancy has already been completed and the assignor has already lived in the property, then our client, being the new assignee, is no longer the first occupant of the unit. So it's really important to see where we are in this new build transaction. Has occupancy occurred? Have we taken possession of the unit yet? And we're just waiting for final closing, or no, that's not the case. The property hasn't exchanged hands, nobody's occupied it. So it's important to identify where we are in that chain, okay? So I put together a list in hopes to clarify the whole HST new rebate aspect in terms of when we will not qualify for the HST rebate, okay? And that's if the intention is flip, okay? If the intention is not to live in the property at the time when the agreement was entered into, or if we're not dealing with an assignment, if we're just dealing with a new build, if someone closes the deal and wants to sell it right away, they're not going to qualify for the HST new housing rebate, okay? Rental properties, if the property is being rented, of course, that's going to disqualify. Or if you have anyone other than a blood relation moving into the property. So that means if you have an aunt or an uncle or a cousin, that you won't qualify for the HST new housing rebate. It has to be your blood relation, so parent, child, grandchild, okay? And of course, corporations are disqualified. There has been an emerging trend in lease backs, okay? And what lease backs are is when you take on a new build, to make it more attractive, the builders will say, we'll lease back the unit for 1 or 2 years and we'll pay you a rent, okay? If that option exists, because the intention from the onset was for the property to be a rental, the HST new housing rebate will, of course, not be granted, and that's that additional $24,000 that we were talking about. Okay, so HST rebate, before I move on to HST rebate, just to backtrack, is that $24,000 provincial rebate that's already included in the purchase price. If you're not dealing with an assignment, you're dealing with a new build, it has to be the primary place of residence of the buyer. If you're dealing with an assignment, 90% of builders will say, no, we're not going to give that HST new housing rebate, apply for it yourself. And if the client has the budget, I mean, that's great. If they don't, then you want to make sure that you have that additional clause in the offer to protect our client, meaning that we're going to make it conditional on getting confirmation from the builder as to whether they're going to honor the HST rebate or not, okay? And if it's been vacant, if no one's lived in there and the assignee is going to be the first person occupying it, they can always apply after closing, provided they qualify and obtain the HST new housing rebate directly from CRA, okay? So moving on from HST new housing rebate, we're going to talk about HST now, okay? So there is an additional component of the 13% HST that could apply to assignments, okay? So when I say could, I'm going to tell you why I say, so your job is already hard enough as a realtor. Now you got to put on, we're not pretending to be accountants here, but I'm just giving you a bit of background so you're aware of the issues and you can kind of guide your client accordingly. But now you got to think about, well, okay, we have this assignment. Does it trigger HST? Is HST going to apply? So if we look at the GST HST bulletins, and if we look at the rules that CRA has in place, the way that they determine whether HST applies or not is whether the assignor is considered to be a builder for HST purposes. So then they say a builder includes a person who acquires an interest in a new house before it has been occupied by an individual as a place of residence or lodging for the primary purposes of selling the house or an interest in the house. So when we say interest, we're talking about that we're selling our interest in the subject property being an assignment. So what on earth does this mean? It's confusing. Or are we a builder for HST purposes? Well, my client's not a builder. So that's not what it's referring to. It's not really referring to whether your client is physically a builder. Their definition to see whether the transaction attracts HST is different. So when they say, are we a builder for HST purposes, they're talking about the intention at the time that the original buyer entered into the contract. So was the intention that the property was going to be their primary place of residence, or was their intention that they were going to flip it? So that's really what it comes down to. That's how CRA really looks at this. It's an intention test. It's a very, very important word, intention. Now, this is a complicated issue. I mean, it's really an issue for an accountant. So as an agent, I don't expect you to sit there and do an intention test. But to protect your client, I would just say you assume that HST applies, because in most cases it may apply if it was bought for investment and it's being flipped and so on and so forth. So to protect your client, you really need to see who's going to pay that HST. Is it going to be the assignor, the person who's flipping the contract and making the money, or is it going to be the assignee, the second buyer who's taking on the contract? Okay. So how does, and we'll get into that in a moment, but how does this intention get looked at by CRA? And well, what's this, the 13%? What does it get paid on, right? What are we paying 13% on? So when they're looking at intention, they're looking at, has the assignor been actively attempting to sell this property? If the financing is beyond the means of the assignor, so it means that they really can't afford it and they bought this. Does the family needs of the assignor align with the personal occupation of the home? So meaning if the assignor is a family of 5, they bought a condo with a den or a condo with one bedroom, clearly they cannot be moving into that property. So it means that the intention at the time was really not for the property to be their primary place of residence. And has the assignor bought more than one unit? So did they buy a multiple, or are they trying to assign multiple agreements? And these are all factors that CRA will look at if the client is subject to an audit, okay? Or has there been an intervening event that explains the need for the assignment? So meaning that they bought it, and then over 5 years they got married, now they have kids, or or their job is now further than the location. So if you're subject to an audit, they're really going to be looking at these factors to determine whether that 13% HST applies or not, okay? So again, because we are not accountants, and because it's really, really a very, very detailed task to determine intention, my advice to you is that the way you draft the contract, the section where it says, is HST included in or in addition to, it really reads, if the transaction is subject to HST, is HST included in or in addition to. So you're determining that if for CRA purposes there is HST, well, who's going to remit it and who's going to pay it, okay? So when acting for the assignee, that second buyer who's taking on this assignment contract, I would push to have HST be included in, okay? So that means that the assignor is going to remit and be responsible for any HST implication. Okay, and I'll tell you what number and how we calculate that 13%. And if we're acting for an assignor, I mean, in addition to, if you can get away with it, good for you. You've negotiated a really good contract for your client where you pushed on that HST liability to the new assignee. Okay. So how do we determine what we're paying HST on? That 13%, what is it getting paid on? Is it on the entire contract price? Is it on the new component of the assignment? What is it? So HST on the assignment is calculated on the total of the assignment fee, okay? Now the fee consists of two components. You have the deposit recovery. What does that mean? That means the deposit that was originally paid by the first buyer to the builder, that on the assignment, they're recovering their deposit back. And now they're making a profit, okay? So HST is paid on the profit. So if I bought a place for $300,000 and I flipped it for $500,000, at $200,000 the gain that's subject to HST, and the deposit that I had originally paid. So I had paid an original $20,000. That's part of the pot as well. You're paying HST on both. Now there is an interesting case, Casablanca Homes and the Queen, where it suggests that the deposit recovery should be exempt from HST. However, CRA is not following this case, and as it stands, HST does apply on the profits made plus the deposit recovery. Okay. Now, what can we do as realtors for our assignee clients? How can we help them in this process? My recommendation is to have a statutory declaration be provided from the assignor, stating that the property has never been occupied as a place of residence or lodging prior to closing. So this is to ensure that they're the first occupants, okay, that nobody has occupied that property before. Okay, statutory declaration from the assignor, stating their intention at the time that they bought the new home, okay, to determine whether HST is payable or not. So it would say that the assignor is providing a statutory declaration confirming that their intention has always, at the time of signing, has been to occupy the property as their primary place of residence, right? And I mean, if they're not providing that, that's fine, but the transaction is taxable subject to HST on that assignment, okay? And an indemnity from the assignor to indemnify and save the assignee harmless from any HST liability. So what this would look like is just a clause that says that the assignor will provide an indemnity on or before closing to the assignee, confirming that they indemnify the assignee from any HST liability. Okay, should CRA view the assignment as subject to HST. Okay, and I guess if you really wanted to, I don't know whether this is realistic or whether a lot of people would really agree to it when you're dealing with offers, but if you can even get an undertaking to have the assignor cooperate with the assignee in dealing with CRA, that would be optimal as well. But if you can't get away with this, statutory declaration and indemnity would be prudent. Okay. I've done up some clauses, and they're here, and I'll go through them with you. And if you ever feel like this presentation was too fast for you, or you really want to take a look and talk to me about these clauses, I'm happy to share these clauses with you and with PICRA, and they can pass these clauses on to you. So when acting for the assignee, the assignor hereby warrants and represents that the assignor has not been and shall not be a builder for the purposes of HST under the Excise Tax Act. So that's going back to that confusing clause from CRA saying, is the assignor a builder? And that goes back, remember, to the intention. What was the intention of the assignor? So this is just to make sure that, so they're going to be saying they're not a builder for HST purposes, meaning that their intention has been for the property to be their primary place of residence. And if this is not in there, again, I mean, you need to be factoring that 13% HST for your clients as part of the assignment agreement of purchase and sale. Okay, then we talk about, well, who's paying the cost for the assignment? The builder usually charges a sizable fee for granting consent to an assignment, and the lawyer fees for the builder will also have to be paid as part of the assignment. So who's paying those costs? If it's not called for in the contract, then you have a situation where you have essentially dropped the ball because that's fine, and nobody knows who's incurring these costs. So you have to, as an agent, make sure that within the AREA assignment of agreement of purchase and sale, you're identifying who's incurring these costs. So you would have a clause that would say the assignor agrees to pay for any and all costs associated for the builder's fee for granting consent to assign the original agreement of purchase and sale. So any cost, I mean, that catches the legal fees associated for the builder's lawyer, as well as the assignment fee that the builder's going to be charging. Okay. We talked about this one, that the property has not been occupied. Okay, meaning they haven't physically moved into the property during occupancy, for example. Okay, and we talked about the credit for the HST new housing rebate, making it conditional on getting confirmation from the builder that your client can get that HST rebate. Okay. Okay, the next one is the assignor hereby warrants and represents that the assignor acquired the property and signed the original builder agreement of purchase and sale with the intention of using the property as the assignor's primary place of residence, okay? And the assigner agrees to provide the statutory declaration. So remember when I went through getting a stat dec and getting an indemnity? Well, here's the clause for it, okay? You can have that the assigner agrees to provide all of this before closing, okay? And then this one talks about the indemnity that I talked about, on or before, you can say interim closing or final closing, depends. If it's a condo, you have 2 closing dates. I hope you know that. You don't have that on a freehold. On a condo, you have the occupancy closing, which is when the builder gives you possession of the unit and you're paying them occupancy fees until final closing where you're getting title. And that only applies to condos, okay? You don't have that on a freehold or on a detached house. So on or before closing, interim closing, it really depends on the context. The assignor hereby agrees to provide the assignee with a written indemnity, agreeing to indemnify and save the assignee harmless from any HST liability in the event that Canada Revenue Agency views this assignment as subject to HST, okay? So that's for the you're putting this in for your assignee, meaning that second buyer, asking for the stat dec and for the indemnity. Okay. Now, talking about Schedule B of the assignment of agreement of purchase and sale. Now, I see these contracts cross my desk all the time, and I get really, really funky numbers. So I just want to walk you through it so we know how these numbers work and what we're inserting. So at number 1 here, total purchase price, including the original agreement of purchase and sale and this assignment. So this is the total price for the assignment, okay? So this is what we're actually selling our interest in this unit for. So I have $440,000 here, okay? Then we have the original amount in the original builder contract. So this means that when I bought this unit, I bought it for $400,000, and now I'm selling it for $440,000. So I'm selling it with a $40,000 increase, essentially. Deposit paid by the assignor to the seller under the original agreement of purchase and sale. This is the original deposit that the original buyer paid to the builder, okay? So this is the deposit recovery. So they paid a deposit, and now they want to get it back. So we have a $40,000 increase here, plus we're getting our deposit monies back. So that totals $100,000 here, okay? So this is your total assignment fee, deposit recovery plus the profit, okay? Now there is a little drop-down box here just make sure that you click on it and take a look at it. This talks about the deposit, the $60,000 that was originally paid. Well, how are we getting that back on this assignment from the assignee? Are we getting our deposit money back at the end, at final closing, or are we getting it when the builder consents to this transaction? So I always like having, upon getting consent of the assignment, so meaning as soon as consent is provided, that the assignor is made whole of the deposit funds that they've paid, okay? But you can have it upon acceptance, you can have it upon final closing, but take a look at that, the drop boxes. Okay, so we got our increase, we got the deposit recovery, that's $100,000. Then we're gonna know how much deposit was paid as part of the assignment of agreement of purchase and sale. So I have $10,000 here, I put that in with my offer. So that leaves a balance of $90,000, okay? So my total assignment fee is $100,000, and I paid a deposit, so that leaves a balance, okay? So the $60,000, we know how the funds are going to be transferring on that, and I have that on consent. But what about this $90,000? Okay, so of most of the offers I see, this $90,000 is not addressed. Okay, we need to have a clause in the offer that says when this $90,000 is being transferred from the assignee to the assignor, right? Now, there's a couple of issues on that, and I'll tell you what it is. So first, establish a closing date. Are we closing 2 days from getting consent? Is that when this $90,000 is being paid? Or are we waiting all the way until final closing? Okay, but either way, you need to have a clause in there that establishes what this closing date is and when the balance of the payment is being is actually being paid. Okay, so when I act for an assignee, so this second buyer who's taking on the contract, as their lawyer, I would not advise my client to pay the $90,000 2 days following consent. And why is that? Why would I tell my client no? The reason is, as soon as the money passes, that $90,000, I mean, what if the deal doesn't close, right? What if the builder goes bankrupt? What if the project is not completed? Then you essentially paid a $90,000 on an assignment contract, and you're not going to be getting the unit. So it puts the assignee in a really, really tough situation where they would have to litigate for the $90,000 that they paid because they never really acquired that unit. So what I like, I mean, if I'm acting for an assignee and if I can get away with it for my client, I will push that we get our money 2 days from getting consent. But really, when I'm acting for the assignee, I want to protect their money and I want to make sure they actually get the unit. So really, it comes down to negotiating and seeing whose side are you on and what you can negotiate for your client. But maybe the middle ground is, so if you're in a situation where you have, savvy real estate agents on each side, and one says, well, we're going to pay the money 2 days following consent. The assignor's agent says that. Then the assignee says, well, no, I don't want my client giving you all the money and not getting the unit for whatever reason. So maybe the middle ground is you make the assignor whole on the deposit money they originally paid to the builder. So if they paid a $60,000 deposit, you give them the $60,000 deposit following consent, 2 days following consent, and then you hang on to and even the balance of the funds can be paid, but it should be paid to a lawyer in trust. It should not be released until the final closing date, until the assignee is actually in a position to get title to that property. Okay, so that's the middle ground. Okay, additional issues that I see, a couple of things that I want to point out to you. When the new build contract is negotiated, there's often closing costs associated with it. These are called adjustments. These are Tarion warranty costs, meter installation, development levies. And when you come to a lawyer, real estate lawyer, our job is really to make sure that those costs are capped, right? Because development levies on some projects are $30,000, $40,000. So my job is to make sure those adjustments are capped. So you have a contract, the adjustments are capped, and now we're trying to assign it. So you really want to make sure when you're advertising, you're not really advertising those caps or any bonuses that's being provided. The reason is most builders, as part of the consent to assignment, will ask for all of those to be waived. So if you have a cap in place, they're going to say, we'll consent to the assignment, but we're no longer offering you a cap, or we're no longer offering you a bonus, okay? So that's why it's important to review that consent document when it's obtained from the builder. Now, advertisement, I get calls all the time. Paria, can I put this unit up on MLS just for a day and then I'll take it down the next day? Or can I put it on Kijiji? Or can I advertise it? The answer is no. The agreement will, I haven't seen an agreement that will allow that. Most builder agreements will not allow you to advertise on any social media, Kijiji, MLS listing. And if you're asking me, if you're trying to push the line and asking me, can I just put it up for a day? The reality is the buyer can be noted in breach of contract, okay, as a result of that. And I've had clients where their agents listed that assignment unit, and the builder came back and said, you're in breach, and to revive the deal, now we want an additional $20,000. So now you're incurring some costs for your client. So you really need to be careful with advertising, okay? You're trying to, it's tough, I know, but you're really just getting an assignment with word of mouth or through the other realtors or brokerages that you work with, okay? Land transfer tax, this is an easy one, but it's good to know. Land transfer tax is not paid just on the original builder contract price, it's paid now on the total. And the total is the builder contract price plus the increase plus the deposit recovery, okay? Okay, changes to Tarion. As of February 1st, 2021, I'm not sure if you have heard, but Tarion is no longer taking care of complaints and licensing of builders. They're only dealing with warranty issues now. And there was a new body created by the government, the Home Construction Regulatory Authority. And as of February, the HCRA is now taking care of all licensing, all complaints. So if you have a new builder client who's getting registered, I mean, they're still registering with Tarion, but they're also registering with the HCRA, okay? So all complaints are going through HCRA, and any warranty issue is now being dealt with through Tarion, okay? Now, let's open up the floor to some questions.
Thanks for your great presentation. I personally enjoyed it a lot. Before I begin with questions,
sure.
Myself as a realtor, I would like to run a scenario to make it more clear. Let's say a client, Mr. John, bought a condo reconstruction from the sales office for $500,000.
Yeah.
Now they assigned it for $700,000.
That's right.
As per your presentation, there's a $200 gain, which the deposit plus the gain will have will get HST.
Correct.
What about the gain? Is the gain capital gain or business gain?
Yeah, so there's two components to this. The HST component that factors into the assignment of agreement of purchase and sale, the HST is triggered on that $200,000 plus the deposit that was originally paid. And as well as for the assignor, there is going to be capital gains because it's not their primary place of residence and they're actually making a profit on this. So they would have to remit this when they file for their taxes, and they're going to have to pay capital gains on it.
Is it capital gain or is it truly 100% business? Because
no, it would factor in as cap. Yeah. So look, I'm not really an accountant, so I don't really know how they factor that in when they're filing for their taxes. But it is a gain, and it is going to be subject to taxes. But whether whether it's really business tax or capital gains tax, I mean, to me, it would seem like it's capital gains tax because it's essentially money you've made on the sale of an interest in a property. But you would have to confirm with an accountant on that. And I have a really good accountant. I'm happy to connect with him and just say, hey, when it comes down to filing for it, and I'm happy to share that information on, any future talks we have. Okay.
Thanks. Now, let me begin with the questions. Mr. Paria from Remax asks, if the original purchase price, as per your presentation, was 1.6, and a signer wants to pay HST, would that HST that's already in it get deducted and then they pay the HST, or they are essentially paying HST twice?
No, so the 1.6 million includes HST on 1.6 million. That's all, right? That's the HST that's included in the purchase price, which is 1.6 million. But when you're flipping it, you're selling it for more, right? So now you're selling it for an extra, let's say $200,000-$300,000. So that extra $200,000-$300,000 is subject to HST. Okay, so the 1.6 million does include HST, but it only includes HST for that purchase price, which is 1.6 million. But now you have this increase plus the deposit recoveries. So now you're paying 13% on the increase plus the deposit recoveries on the assignment. So two separate HSTs are payable. But on the assignment, you're not paying HST again on 1.6 plus the increase plus the deposit. You're paying HST on the increase and the deposit recovery. Okay, so the HST is already included for the 1.6. That's part of the purchase price.
Great. And the next question is, you touched on it. What if the buyer rents the unit for more than a year? What's the process to get the HST rebate?
Yeah, very good question. So you can apply for it's called a rental, it's the rental HST rebate that you're essentially applying for, and you will get that from CRA following closing. So you will pay that $24,000 on closing. You need a long-term lease in accordance with the requirement. So you need to have a 1-year lease at a minimum. And once you have that, I mean, you apply for the rental rebate, and as long as you have a long-term lease in there, I don't see why you wouldn't qualify. So there is a rental rebate program available. And if you Google it, it'll take you right to the form. So if your client ever wants to apply, the forms are right there on the CRA website.
Now, I have one question myself. The previous one was myself, that I'm waiting for more questions to come in. What if the assignment is on an agreement and the purchase and sale on a resale? Let's say a property was sold from 1.5 with a long closing, and sometimes when the prices are going up, you have the opportunity in the middle to assign it to another buyer.
That's right. You're talking about not new build, resale.
Yes.
Resale assignment.
In that case, do you still need the consent of the original seller or no?
Very good question. Very smart question. Okay. So resale assignment is it's an actual business now. It's a very niche business. And I have clients who quit their full-time jobs because all they do now, they have a buyer's list and they, purchase properties and they flip it. And the amount of money they make shocks me. It makes me want to quit my job and join, run my own office. So it's a niche area, and it's certainly out there. The law basically says you can assign your rights, but not your obligations. So in accordance on a resale or RIA contract, no, you don't need consent. You can assign that consent. The reason why you need it on a new build is because the builders will go that extra step in inserting a clause in their offer that says consent is required. Yeah, no consent is required.
And I'm waiting for more questions. And Mr. Safi asked if HST applies on the vacant land, and once that's been assigned, what happens with the HST application? Right.
So vacant land it's a whole different, the requirement on HST on vacant land is different. HST with assignments, I said it's the intention test really, and the question becomes, is it exempt, does it apply? But to protect our clients, we're going to say that we're going to assume that it applies, right? Vacant land, it depends on the use of the current seller, okay? So obviously on commercial land, okay, it's subject to HST. And then where you have the use of the existing seller. So if you have a seller who's, you know, farming the property, or there is income associated with that property, then it's in the course of the business, right? So that triggers HST as well. It's a totally different test, but yeah, on a vacant land, HST could apply as well. Okay.
Okay, I would like to ask participants if they have any more questions, please feel free to write it down on the comment below, and I will ask Paria. I think we don't have any more questions.
Okay, that's okay.
And I'm not gonna hold you back any longer. I know it's month end and you have lots of work to catch up.
Thank you.
Once again, on behalf of Pickering, I would like to thank you for your time. And I would like to thank Canada Create for allowing us and to be here in the background, to allowing us to host this webinar. And just so you know, to all your participants, this webinar will be saved on YouTube channel, and you can always come back and view it for later needs. Thanks again, Paria.
Thank you for having me. And if you have any questions, I'm always, you know, my door's open, happy to address any questions or concerns, okay?
Sure.
It's a pleasure. Thank you.
Thanks a lot. Enjoy the rest of your day.
Okay, bye-bye.